Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado. You're watching All Up in Your Business, where today we are going to go through your comments and answer your legal questions. One of my favorite things to do. Before we start all of that though, if you're new to All Up in Your Business, welcome. I'm so glad you're here. Keep in mind, while I am a lawyer, I am not your lawyer. The stuff I talk about in this video is not to be taken as a substitute for actual legal advice. If you need help with any legal situation, you should consult with a lawyer who's licensed in your state. So even though I am answering legal questions, it's not legal advice. Keep that in mind. And while you're here, make sure you check the description for links to additional information and resources. I've got links to download my free trademark guide. You can check out my DIY trademark course. You can get some resources to help you with starting a business or running your business, contracts, all kinds of cool stuff. All of that you can find down in the description. And I think that's it, so let's dive into your questions. We've got a big one right off the bat. I have a few important questions after watching your video. How do I protect my single member LLC from liability after processing personal transactions from my business credit card, but paying the transaction straight from my personal checking? I thought this wouldn't be considered commingling as I paid the transaction from my personal checking account, but I've learned otherwise. I want to protect myself legally from this mistake that I've already unfortunately made, please. Is there something that I can do within my operating agreement to protect me from something like this? And do I also need to add books or keep the transactions out of books since it was paid out of personal checking, not the business checking? Sorry in advance for all the questions. So let's start with the first one. How do I protect my single member LLC from liability after processing personal transactions from my business account? I think you mean, how do you protect yourself from that liability? The spirit of this question, I think what they're going towards is this concept of piercing the corporate veil. If you're not familiar with it, setting up an LLC, the idea is that you as the individual member, the owner, aren't going to be liable for the stuff that your business does. If your LLC is liable for something, it's your LLC and not you. But that's not a perfect setup. There is this concept of piercing the corporate veil where, despite the LLC's existence, you as the member could still be held liable for something that the business does. And a part of a factor that goes into that is commingling business and personal assets. So using business funds for personal expenses or vice versa. So it sounds like what happened here, this person used their business credit card to pay for a personal transaction and then paid the credit card from their personal checking. With all of this, what can you do after the fact? Usually not very much. These little things, these little isolated transactions, especially if they were unintentional, I've done this before. It happens. I am at a store not thinking and I pull out my business credit card and I use it. Or sometimes I forget to bring my business credit card with me and I have to pay for something business related with my personal card. These one-off isolated instances usually aren't going to be enough to put you at any real risk. It's the accumulation of these transactions happening over and over again, it becoming a regular habit, you treating your business like it's your own personal bank account. That's when it's going to come in and kind of bite you in the ass or get you in trouble. So this situation, what you did, paying it with your personal funds, that's a good idea. So you'd say, whoops, shoot, I shouldn't have used my business credit card for that. In the end, you're using personal money to pay that expense, even though it shows up on your business card. Is it considered commingling? Again, that one-off transaction, technically, yeah, I guess, but it's not going to be commingling probably in the sense that it's going to get you into any real trouble. Moving forward, be careful. Try to avoid this from happening. What can you do within your operating agreement? Again, there's nothing really that you can do retroactively to cover what you did, but a really common term in an operating agreement is something that acknowledges that the members aren't to be held personally liable for the acts of the LLC. And this is inherent in the law anyway, but we usually put it in the operating agreement just to like be super sure. But it'll say the acts of the LLC are not acts of the members, and the members, as to the fullest extent permissible, shouldn't be held liable for the LLC's acts. And there's often also an indemnification provision where the LLC is agreeing to indemnify the members if they are determined to be liable. So you could amend your operating agreement now to put that terminology in there if it isn't already. Add books or keep the transactions out of the books. That's not gonna hurt or harm you. I think, you know, exactly what your books state. Don't take it as a business deduction, whatever that expense was. Don't try to act like it was a business expense. Sounds like what you've done is fine. Don't freak out about it. Be careful moving forward. Again, these one little isolated instances aren't going to be what sets you over the top as far as liability and piercing the corporate veil. It's okay, it happens. Oh, another long one, okay. Greetings, Aiden. Thank you for your videos, you're welcome. They're very helpful and informative for those who are all about DIY. As far as getting trademarks, I do not believe I've seen anything from you specifically regarding band music group names. I think the category we'd use would be under entertainment. Yeah, typically that's one of the categories. I used the USPTO to search to see if the name we're using can be obtained by us in the entertainment category, and we didn't find anyone using it. However, we did see others using it in a different category. May I ask, does that mean that we can use the name as long as it's in a different category? We are called hauler. A few others are using it in the transportation or logistics sense, but not entertainment. Your first question, the category, the class for musical artists, bands, being entertainment, that is almost always one of the ones that we would include for a musical artist. Entertainment services in the nature of live performances by a music group, something along those lines is pretty typical language. But bands also put out music, so maybe physical CDs, if people do CDs or records still, then you might want to register under the appropriate class for CDs. Downloadable music, I don't think that's in the same class as entertainment, but downloadable music would be a different class as well. But yeah, kind of entertainment would be appropriate for a musical group. Just because something is, if you search and find another trademark, just because it's not in the same category or class doesn't automatically mean that it's not going to be a conflict. Also, you know, even if it is in the same class, that doesn't automatically mean it is going to be a conflict. It depends much more on the nitty-gritty facts and details. But, you know, if we're comparing a musical group and transportation logistics services, if the names are identical, those goods and services I don't believe are considered related to each other. Off the top of my head, I can't think of any instance where musical entertainment group services are considered closely related to transportation logistics. Another thing to keep in, you know, that applies here is the name itself, hauler. There's this thing with trademarks that go into commercial impression and meaning and connotation of the trademark. When we look at the trademark in the context, when we look at hauler in the context of transportation services or logistics, hauler means something. We're hauling stuff, or we're helping with the logistics of hauling things. Hauler has a distinct meaning, commercial impression in the transportation and logistics industry that probably doesn't exist when we apply it to entertainment and musical group services. So just based off completely what you've told me and not doing any further research and not knowing anything else, there probably wouldn't be a conflict between your musical group hauler and these hauler transportation logistics services. Can't guarantee it, can't promise it. You never know, stranger things have happened. But no, I don't think those would be considered related. You'd probably be okay. But it's best to consult with a trademark lawyer for actual advice on the matter. Can I create a logo to use in my online storefront without registering it? Absolutely. You do not need to register a trademark with the USPTO in order to use it. You can create a logo and use it in your business on your online store. You're free to do that. No requirement. It's a good idea to register it. You get a lot of additional rights and benefits with it, but it's not required. You can just create the logo, use it. Actually, the first step before settling on a name, company name or logo is to verify that it is not already a registered trademark or service mark. Quite often you will find that your desired branding would infringe upon another company's registrations. I don't know exactly what video, what context the actually is coming up in here, but yeah, I agree to an extent with this. Before you settle on a company name or a logo, it is a really good idea, the first step being to clear that name or logo. Make sure it's not going to be infringing on another party's trademarks. The caveat to that is there's no guarantees. Anything in the law, really, but with trademarks in particular, there's no guarantees. I do clearance searches for my clients all the time. They'll come to me with their prospective brand name, their company name, their logo, and they want me to do a clearance search to see if they can use it. Almost never do I come back with a yes, you are 100% in the clear. There is no world in which this will conflict with or infringe upon another company's trademark. I can't know that for sure. I can't make that guarantee. There have also been situations where I've registered a client's trademark. It has gone through the process seamlessly. The USPTO had no issues. There was no conflict, no likelihood of confusion. It went through the process smooth, easy, no problems at all, gets registered. And then a year later, another company comes in and says, actually, we're going to challenge your registration now because we think it's infringing on us. So even if I say it's clear to use and the USPTO agrees with me, none of that is 100% guarantee that we're never going to run into any problems. So yes, it's true that the first step should be making sure it's not already a registered trademark, but there's no way to make sure 100% that it's not going to be infringing on another company's registrations. That's kind of just the risk that goes along with operating a business. We can do everything in our power to limit exposure and risk of stuff happening, but we can never eliminate it completely. Just not a possibility. So should you trademark your company slogan with your company name or do them separately as well? Because from doing research says slogans are hard to trademark by themselves. Generally speaking, it's best to do them separately. Company name is one trademark, one distinct trademark. Your company's slogan is a second distinct trademark. Sometimes we use them together, name followed by slogan. You might see that out in the wild or in a logo or on branding materials. We'll see the company name followed by the slogan. So it would be possible to register the trademark for both combined, but often also we use them separately. Name is used separately, slogan is used separately. So ideally you would do both. Probably register them separately and register them together if you use them in all those different variations. But typically, you know, if we have to decide or prioritize, then we'd want to do them separately. The thing about slogans being hard to trademark by themselves, they're no more difficult than any other kind of trademark. A slogan is registered and goes through the registration process with the USPTO in the exact same way that a company name or any other standard character mark or really any other logo would. So it's no more difficult than any other trademark, usually. Can you still be a sole proprietor and have contracts for clients assigned to protect you? Absolutely, absolutely you can. This is kind of related to the first question that I answered about, the piercing the corporate veil and protecting yourself from liability. The LLC is one method by which we as business owners can protect ourselves personally. The LLC is one method of doing that. It is not the only way, and it's not the end-all be-all method either. The LLC protects you individually from liabilities of the company. But what we want to do even more is try to avoid those liabilities altogether. If the liabilities never arise, we don't have anything we need to protect ourselves from. And contracts are a great way to limit potential liability exposure. I've said it a few times throughout this video, there's no way to completely get rid of risk and stuff with running a business. Same goes with contracts. There's no such thing as a impenetrable contract or rock solid contract. There's always going to be ways to invalidate or get around a term in a contract. But having a good, solid, well-drafted contract that you have your clients sign is going to go very far in protecting yourself if you operate as a sole proprietor or as an LLC. So yeah, absolutely, you can still be a sole proprietor and use contracts to protect yourself. Same with insurance. Insurance goes a long way to protect yourself. And then, all three together, contracts, insurance, and LLCs, you're kind of covering yourself from different angles. But yeah, good question. The answer is yes, you absolutely can. Can I deposit a check made out to me into my business bank account? Can you? Yeah, probably, assuming your bank will allow that, which if you're like an LLC, single member LLC, usually they will accept checks that are made out to you individually. That's not uncommon, even if you're operating as an LLC. Clients sometimes accidentally, or, they don't know better, they make a check out to you by name. So can you deposit it into your business bank account? Depends on your bank, but probably yes. Should you? If it was intended for like payment for your business and the customer, the client just made the check out to your name, to you personally in your name, probably not an issue. If it's like a birthday check from your grandma, though, can you? Yeah. Should you? Probably not, because it's not business money. You should deposit it into your personal account, and then if you want to like put it into your business, contribute it to your business, you can then write a check from your personal account into your business bank account. But depends on the circumstances. Can you? Yes. Should you? Maybe. Oh, I have a question. It's about all those fake mails you start getting from third-party LLCs trying to look like they're an official government entity. This is a thing. When you start a business, even more so when you start trying to register a trademark, you get lots of mail, emails, communications from companies that look like they are some official government entity. They're not. I thought they were supposed to declare somewhere on the letter that they aren't a government agency and they are actually a private third-party company. But I just got a letter recently and nowhere does it state this. Are they breaking the law? Can I finally sue one of these people using this letter as proof? I don't know the exact law on this. I know generally though, deceptive trade practices are unlawful, and that is kind of the core of what a lot of these companies are doing. They are intentionally trying to deceive you, the consumer, and make you think that this letter is coming from an actual government agency. And in that instance, I believe, yes, they are supposed to declare somewhere on the letter that this is not a government agency, we're a private business, stuff like that. Yes, they should do that. Sometimes it's really hard to find. Sometimes it's like smaller print or in a place you wouldn't look. I don't think that's acceptable either. If it doesn't state that anywhere, are they breaking the law? It's hard to say for sure. Very well could be, probably. But can you finally sue these people? That part I don't know. I don't know if there is a private cause of action for these types of business practices. There very well could be. I'd have to look into it. I don't know off the top of my head if you can sue. It might be a situation where like the FTC, the Federal Trade Commission, has to go after these companies for these unlawful practices. If you can't sue, talk to a lawyer, someone who does civil litigation, someone who sues people. I don't sue people or companies, so I don't know off the top of my head, but talk to a lawyer. You might be able to sue them, but I think more likely, I don't believe there's a private cause of action here. But report them to the FTC. Report them to the Federal Trade Commission and maybe to the Attorney General of your state. Because I think more likely than not, this is something that the government has to take action against rather than you as an individual party. The takeaway primarily from this question that I want everyone to pay attention to is you're going to get a lot of crap in the mail when you start a business. Be very, very wary of it. All of it. If they're asking you to pay money. 99% of the time it's fake. Scam, spam, or just a company kind of trying to trick you. Same with phone calls, emails, text messages. Don't send money to anybody anymore. Ugh, like that's kind of the takeaway. Don't give people money anymore. I don't really understand. If trademarking it without color is covering every instance of use of color, or with or without, why bother with color trademarks? When we talk about trademarking a logo, you can do the trademark with or without a claim to color. And I believe what this question is I almost always recommend starting without a claim to color. So you protect your logo in black and white basically, and it's protected regardless of the color that you use it in. So if that's the case, why bother with the color trademarks? It was only very recently that I truly understood the answer to this question. The answer is because we use it in a specific color. So we want to protect it in all colors. We want to protect it visually, but we also might want to protect it in color. Why? It might come up, it might be useful. I have a situation right now with a client where we have their logo registered without a claim to color. So their logo is registered in black and white. We found another similar business that was using a logo that is very similar to theirs, but there's also a lot of differences. But they're using their logo in almost the exact same color as my client uses. So without that color, it's a little more questionable of, is this confusingly similar? Is there infringement here? But when we apply the color, it becomes much more obvious that there is a conflict. So there are these instances where the color makes a big difference. That's kind of the answer here. Usually, you know, sometimes color doesn't matter, sometimes color matters a lot. So best practice is to register your logo without a claim to color and with a claim to color, because sometimes it makes all the difference. And that's what we've done. You know, we came across this and I said, well, you know, let's address it, but also let's start working on getting your color version of your logo registered, because now we know we might need that. Stuff comes up, you figure it out. All right, last one, I think. Can I change my business address later down the line? Yeah. You can change your business address whenever you want. It's not always easy. You have to like file documents with the state, file documents with the USPTO, file documents with the IRS. Any government agency, you know, you have to update your clients, you have to update your bank. It's not easy, it's kind of a pain in the ass, but yeah, you can change your business address whenever you want. All right, that's all for this episode, folks. If you learned a thing or two, give me a thumbs up, subscribe if you haven't already, share this video, check the description for additional information, additional resources, all kinds of fun stuff down there. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.